Good morning. This is our first video in the crimes course. Uh, we've covered quite a bit of ground, or if you will, the postings I put up have covered quite a bit of ground. Unfortunately, we're not together, and I'm hoping that a weekly video will be of help in kind of bringing us closer together as we work with this distance. I find it an odd way to work with students. Kind of feel like I'm in a fishbowl and I'm talking to you and yet you're not present. In any event, I want to kind of summarize where I think we've been and make a few points to clarify a few items. I'm going to be posting an exam at the end of the week. When I say an exam, it'll be worth 20 points as I put forth in the course outline and in the course syllabus. So what we've done so far, or what I have posted so far, is that we identified 4 possible outcomes in a criminal case. We then looked at how the New York State court system processes criminal cases, violations, misdemeanors, and felonies. When we spoke about felonies, we added the grand jury, because a person cannot ultimately be charged with a felony without a grand jury issuing an indictment. We then, after we looked at the New York State court system, we looked at the federal court system and how it processes criminal cases brought under federal law. And you know, the deal with that is, if we had our hypothetical law firm in Buffalo and we did criminal defense work, we would, at least from time to time, be representing defendants charged with criminal offenses in federal court, as opposed to defendants charged with state offenses in state court. The point I wanted to make, and I made this in the posting, but we should be sensitive to the fact that a criminal case beginning in the state court system can end up in the federal court system if there is a federal constitutional issue in the state criminal case, and the defendant has been unsuccessful at all appeal levels in the state court system. That defendant can ask the federal court system, typically it'll be the United States Supreme Court, to look at the case. And the argument that the defendant is raising is that my state criminal conviction should be overturned or reversed because it was obtained by way of a violation of one of my federal constitutional rights. The example I use in the posting is the famous or infamous case of Miranda versus Arizona, which was a state criminal court case. The defendant had been convicted in Arizona state courts, unsuccessful in the state appeals, and then asked the United States Supreme Court to review his conviction, which it did. The federal issues were the confession was obtained in violation of the defendant's Fifth Amendment privilege against self-incrimination and the Sixth Amendment right to counsel. And from that Supreme Court case, we end up with the so-called Miranda warnings, or the Miranda rights. I just wanted to emphasize that we can see a state criminal court case end up before the United States Supreme Court. And then I wanted to talk a little bit about the next item, which was the first look at general principles of criminal responsibility. And I posted that the traditional view of criminal liability is that the defendant has done something, or perhaps not done something, and has acted or failed to act with a certain state of mind. And back in the day, in what we call the common law the first part of it, the doing or not doing something, was called actus reus, and the guilty state of mind was called mens rea. We then brought those concepts down to earth and looked at the provisions of the New York Penal Law in Article 15. We noted that actus reus in penal law terminology is either a voluntary act or an omission, and mens rea would be one or more of four culpable mental states: intentionally, knowingly, recklessly, and criminal negligence. I think that the most difficult and challenging part of understanding those concepts that I just identified in the penal law would be the two culpable mental states of recklessly and with criminal negligence. And both of them really address a dilemma in the criminal law, wherever you're going to have a system of criminal laws. And that is, what do we do with a defendant who has harmed someone but didn't intend to harm someone? And the way the criminal law has, at least in New York State, has worked that out, in most other states too, is that the defendant must be, or must have acted in a manner that was extremely or grossly negligent. And that calls into play then the concept of negligence. What does it mean to be negligent, or what is negligent conduct? And really what the law has done is invent a fictional person known as the reasonable person. You know, it's the person who's always careful and takes due care, not like you and I some of the time. In any event, the idea of negligence is that in any given situation, a person has failed to act like a reasonable person would have acted in the same set of circumstances. So if on the way to my law office this morning, I was driving 50 miles an hour in a 35-mile-an-hour zone, which I suspect I was at one point, that would be negligence, because it would be in violation of the standard that a reasonable person would have followed. We don't get or reach the point of criminal liability simply with negligence, however. When we look at the definitions of criminal negligence and recklessness, they both require that the defendant, as I noted, act with extreme negligence. So mere negligence or just negligence isn't enough. It's a question of fact, but if we reach the point of extreme negligence, maybe if I've been driving 50 miles an hour and the road conditions, which they weren't this morning, but were very icy, and maybe if I wasn't paying attention at all to the driving because I was fiddling around with my iPhone or the radio, possibly we reach a point where you could say there's extreme or gross negligence. If we do reach that point, then the question becomes, well, was that behavior reckless behavior, or was it criminally negligent behavior? And that is decided, that question is answered by taking a look at something known as risk perception. And if we can conclude that the defendant was simply unaware of the risk his extreme negligence or her extreme negligence created, that would be criminal negligence. If, however, the finding is made that the defendant was aware of the risk created by their conduct and they disregarded it, that would be recklessness. If you think about it, recklessness is more blameworthy than criminal negligence. And then finally, on that point, there's a bit of a wrinkle. If a defendant is extremely negligent and unaware of the risk because of extreme intoxication, then we conclude, according to the New York Penal Law, that defendant is also reckless. So that kind of summarizes in a very brief way, of course, where we've been. I encourage you to ask questions whenever you have them. I'm good at responding to them, or if I'm good at my response, I hope so. That's my law partner who just walked in the room to adjust the thermostat. But what I wanted to point out is if you have questions, please send them to my college email rather than leave them in a message on Blackboard. Blackboard is very difficult to work with on a mobile device. My college email is easily accessible on a mobile device, so that's why I asked that you do that. And again, I'll be doing these videos now on a weekly basis. By Friday, I'll have that 20-point evaluation posted. I don't believe I'll have any other postings this week in the course after this video, and you'll have a week to deal with the evaluation / I called it, I believe, the test. And again, I encourage you to ask questions. I regret that we're not together, but we'll do the best that we can. Thanks.